Hello, this is Matt on the Moon Lambo channel. In a development earlier today that will surprise absolutely no one, the SEC has requested of the judge more time to respond to Attorney John Deaton's motion from just a few days ago, May 21st, in which Attorney Deaton wrote the following. Amici, so that'd be everybody that he's representing, the 67,000 plus XRP holders, he said, Amici request permission to file brief regarding SEC expert who claims to know motivation of XRP holders when purchasing XRP. Amici also seek access to experts' report and deposition testimony, end quote. So he's referencing there the guy that the SEC's paying to prove what the motivations of XRP holders are. Patrick Doody is the expert's name, the alleged expert's name. The SEC paid to write a report which is supposed to prove the intentions of XRP holders. And so here you have Attorney John Deaton asking for access to that report because the SEC doesn't want it handed over, and also wants access to deposition testimony, and just wants to file a brief in general on this topic. So that was as of May 21st. Now we get word today that the SEC, yet again, wants to engage in a delay tactic. Now, Ripple actually agreed to this proposed adjusted timeline from the SEC, and Attorney John Deaton did too. So if that surprises you, well, he wouldn't do this without reason. In fact, he has a very good reason, which I'll be sharing with you in this latest Moon Lambo Hot Jam. I've got opinions from 4 attorneys within the XRP community, in fact, and another absolutely astonishing development, frankly. You're not going to believe it. No, you'll believe it. You'll believe it. SEC Supreme Leader and Dictator Kim Jong Gensler put out a video today from his official Twitter account in which, in this clip, the video clip of him from his official Twitter account, he states, we'll get the exact wording when I show this a little bit later in the video, but he said, and he's talking about crypto regulation, we'll figure out how the regulations work. He literally said that, and again, I'm going to give you the full context and verbatim what he wrote, but he said, we'll figure out the regulations. Come on in and talk to us. Get yourself signed up with the SEC as a registered entity. We'll figure out the regulations. I thought it was very clear what the regulations were. Unbelievable stuff here, folks. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. A shout out and credit to XRP community member James Filan for sharing this legal document filed by the SEC today, as well as Attorney John Deaton's crypto law organization. Both shared this on Twitter. And it's very short, so I'm just going to read the whole thing. It's on your screen. It's super short. Here you can see, from the SEC, Dear Judge Torres, pursuant to Rule IC of the, I guess it's supposed to be 1C, of this court's individual practices, Plaintiff Securities and Exchange Commission respectfully requests that the court extend the SEC's time to file an opposition to the letter filed by counsel for 6 Amici Curiae dated Saturday, May 21st, 2022. John hasn't even had an opportunity to write the damn brief. Here you go. Let the SEC's doing this. Anyway, it continues. So, again, they wanted to delay until here, June 7th, 2022. That's what they want the deadline to be. Though the letter was filed as a letter motion, the SEC understands the letter to be a pre-motion letter as required by Rule 3A of the court's individual practices. Ordinarily, the SEC's opposition to this pre-motion letter would be due on Tuesday, May 31st, 2022. In light of the upcoming holiday and other briefing deadlines, the SEC respectfully requests an extension of this deadline until Tuesday, June 7th, 2022. The holiday? And what other briefings are they talking about? They don't even cite this. They don't even have to be specific when requesting something like this. That's fascinating. And then they continue. They say, this is the SEC's first request for an extension of this deadline. Defendants have informed the SEC that they have no objection to this extension request, as long as the SEC agrees that any response by defendants would be due by Friday, June 10th, 2022. The SEC has no objection to this proposed deadline. Counsel for Amici Curiae has informed the SEC that they have no objection to the SEC's extension request. And so there you go. The most relevant, interesting portion of this is just those last few sentences in which you see that Ripple's fine with this extension, that the SEC is proposing, so long as Ripple also gets an extension. Theirs would be till June 10th to respond to that. And you can see here at the very final sentence, counsel for Amici Curiae, so that would be John Deaton, has informed the SEC that they have no objection to the SEC's extension request. So here's what Attorney John Deaton had to say about that. He wrote, I'm well aware of the frustration XRP holders have regarding extensions, but please understand it would have looked very poorly and without consequence for me to object when the parties are in agreement. So that seems abundantly and obviously true. So I can understand when you hear extension, what's the first thing you think and feel? Yeah, it's probably the same for me. We're probably all thinking and feeling the same thing. But upon understanding that, okay, Ripple didn't object to this, whatever their rationale is, I don't know, maybe they're just trying to not look too combative on something that isn't going to change the actual timeline of the court case. But Attorney John Deaton's point out here, look, when the two party participants, you're talking about Ripple and the SEC, both agree, what good would it do for him to be kicking and screaming on something that is ultimately going to be inconsequential, right? So that's the reason. And then he also wrote this. This is from Attorney Deaton. This doesn't affect the scheduling timeline at all. It only means the parties have more time to respond to my motion. We are not a party, and the two parties are in agreement. So I'll just pause to note. He's saying that as a Amici counsel here is not technically a party. Amici, it's the friends of the court, but it's not the case that John Deaton is representing defendants. He's not. They're friends of the court. And so Attorney Deaton says, we are not a party, and the two parties are in agreement. Since this doesn't impact the actual timetable, it would potentially alienate the judge to object. See, that seems to be pretty reasonable to me. Now, here's an attorney within the XRP community. His name's Bill, and here's what he had to say about this expression of concern. He wrote, my concern is the SEC will make an alternative argument that if Amici are allowed to participate at all, that the SEC need expert discovery reopened to file a further supplemental report of Mr. Duty so he can desperately repair his report. They will find some excuse to delay. Yeah, so here's what I'm thinking. The report, if it's going to be very similar to what Mr. Duty wrote for the Telegram case, because mind you, this isn't the first time the SEC hired him. They hired him for the Telegram case, and that worked out for them. If it's going to be similar to that, I think that Mr. Duty is going to find a lot of pushback this time that he didn't see last time. I think that Attorney John Deaton is armed with a bunch of facts and real information that's going to destroy this thing. And if they haven't thought through this and haven't recognized that to this point, then I don't know. I don't pretend to have a legal background, but Bill's expressing a concern that perhaps the SEC could at least attempt to have this thing reopened. And so I couldn't speak to whether or not what the likelihood is of them is attempting to do that, or what the probability of such a request being approved by the judge would be if they even make that request in the first place. But I will say that I think they're going to find themselves in a world of hurt either way. Then there was this from attorney, an XRP community member, Fred Rispoli, who responded to this with the following. SEC needs more time for a response it already wrote in example 2 of John Deaton's letter motion? Of course it does. Now we know why attorney Jeremy Hogan said in his last video it was better to get on this early. John's Amici brief will demolish the SEC until it looks like duty. I like that last part especially. What a name. And then there was XRP Crypto Wolf, member of the XRP community. Excuse me. Sorry, folks. Let me get some water here. I've been talking a lot today, not just on YouTube. Anyway, so XRP Crypto Wolf said to Attorney Hogan, what kind of impact will John Deaton's brief have in the XRP lawsuit if the judge approves it? Attorney Hogan said, his client can directly attack Mr. Duty's opinion. That is very persuasive and very important. It's almost as if John's and his client's presence was meant for this moment. Gotta love that. And then there's this, and this is the more absurd portion of this latest Moon Lambo hot jam. Here's the tweet from today. It's just this morning from SEC Supreme Leader and Dictator Kim Jong-Gary. It's his official Gary Gensler Twitter account. And he wrote the following. While crypto markets may offer new ways for entrepreneurs to raise capital and investors to trade, we all still need investor and market protections. Let's not risk undermining 90 years of securities laws and create some regulatory arbitrage or loopholes. Then he shared this 2-minute, 16-second video clip of himself talking about crypto-related stuff. And he's basically talking about, hey, look, if you're going to be a market participant, and this part I am paraphrasing, if you're going to be a market participant, come in, we'll get you registered. That was his message, you know. But you got to do it by the books. That's what he's saying here. And he doesn't seem to understand that there's more reasons for the cryptocurrency asset class to exist than just raising capital and for investors to trade cryptocurrencies. If you look at that tweet, though, he seems to think that's all it's for raising capital, which makes the SEC seem super duper relevant then, and for investors to trade these securities. That's the message that he's conveying here. Well, look what attorney James Filan found. And I actually read this tweet from attorney Filan before I had a chance to watch the video clip myself yet. But he quoted Gensler, and the quote from Gensler was as follows: "We'll figure out how the regulations work." End quote. And then Mr. Filan wrote, so much for regulatory clarity now and over the past decade. So I was like, whoa. He really said that? And so I was like, I got to watch this. So I stopped what I was doing and I watched the damn thing. And sure enough, he did. So I put out this tweet with this screen grab from the 1-minute, 48-second mark, which is subtitled. These subtitles, I didn't write that. That's from Gary Gensler's video. It's on your screen right there, which reads as follows: "We'll figure out how the regulations work." Unbelievable. And so here's what I wrote in this tweet. I wrote, Kim Jong Gensler posted a 2-minute video about crypto today. He encouraged market participants to come in and speak with them about registering with the SEC. He verbatim stated, quote, "We'll figure out how the regulations work," end quote. Accidental truth? I thought regs were clear. I thought, yeah, didn't you think the regulations were super duper crystal clear, very clear, in fact, as Kim Jong Gensler has stated in the past? It's just every now and then he says the quiet part out loud. The truth comes out accidentally, because when you're lying, it's hard to keep up with your lies the whole damn time. I don't think this is him misspeaking. He knows that there's not sufficient regulatory clarity. He stated it before he came SEC chair. He's on video stating that there wasn't regulatory clarity for Ripple and for XRP. He specifically was talking about them, which was one of the most astonishing developments. I can't remember when that was. Maybe it might have been over half a year ago at this point. I think it was at some point last year, but the video surfaced of him admitting that. And so now he's as SEC chair saying, yeah, well, we'll figure out the regulations. Just come on in, we'll figure out the regulations afterward. Because he knows that's the process that would actually occur if anybody comes in. And then you're just, you're a big old hammer, and you see a nail, and you whack the nail down if you're the SEC. That's the way that they look at this. Highly offensive, but wow, how telling is that? Astonishing, right? I don't know how the SEC, even in the SEC versus Ripple case, when your current SEC, because by the way, this video clip was from April this year. I don't see how, when you have the SEC chair admitting that there's not sufficient regulatory clarity, the SEC can then, in the SEC versus Ripple case, argue that there is sufficient regulatory clarity for market participants. It does not make sense. Attorney John Deaton had another take on this, so he shared that video clip and wrote the following. He's basically saying leave everything to him and not provide guidance or do anything similar to what the UK's Financial Conduct Authority or Japan's FSA have done. He prefers regulatory uncertainty and vagueness, which will allow regulation through enforcement to continue. It's astonishing stuff here. And there's this from Stuart Alderati, who is Ripple's general counsel, so he's their top in-house legal guy. He also shared that video from Kim Jong Gensler, and Stuart Alderati wrote the following. We all agree that consumer and market protections are needed, but saying that every token besides Bitcoin, maybe, is a security is a combination of bad law and bad policy, all in the name of the SEC's political land grab over this asset class. The SEC's jurisdiction is not limitless. Oh my gosh. Isn't that the truth? So it's beautiful to see this stuff. It's absolutely beautiful to see this. Let me know what you think below. Like, again, not surprised to see a delay. It's like, kind of shocking, but not surprising to see Gary Gensler letting the truth accidentally come out and then actually tweeting about it today and then not even realizing that he was tweeting about it in a way that goes against what the SEC is currently arguing and ongoing litigation. It just is what it is, folks. Please let me know what you think in the comment section below. I'm rather curious, but I'll wrap up here. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.